us for the latest episode of Kelleher and Holland's Employment Law Lunch and Learn webinars. I am Amy Rizzo, I'm the marketing manager, and we have a sweet treat for you today, the scoop on effective workplace investigations. Our panelists serving up samples today are two of our coolest attorneys, Madeline Kelleher from our employment law group and Mike Morrison from our litigation group. So, quick question before we get started. What's your favorite ice cream flavor?
Ooh, that's a hard one. I think I'm gonna have to go with mint chocolate chip.
That's a good one. I would go with Rocky Road, no
Mm.
doubt.
Excellent, excellent. I was wondering if I was going to get a plain vanilla, folks, but
It
you
was
mixed it
between
up.
that. Yeah.
Excellent. All right. Well, let's get the scoop started with you, Madeline, if you want to introduce us to our topic today.
Yeah, absolutely. Hi, everyone. So investigations are a critical component of an effective compliance program. Even companies with the best compliance programs inevitably experience violations of law and company policy, which may subject the company to criminal and civil liability, harmful publicity, and loss of public confidence. Today, we will be discussing what a company should do when it learns that a legal or company policy violation has taken place, including when internal investigations are necessary, how they tend to come about, preparing and performing investigations, and other considerations.
So, Mike, when is an internal investigation necessary? So, how does one typically start?
Great, thanks for the question. Employers must generally conduct an internal investigation when they learn what's called a triggering event, which is usually a formal employee complaint or an internal process that uncovers suspicious employee activity. The triggering event may also be from an attorney's demand letter, an EEOC charge, or an informal complaint made pretty much at any point in time in an employee's job uh, scope, such as a performance review, conversations over lunch, etc., can be pretty wide-ranging. Generally, an employer must promptly investigate allegations or suspicions of employee misconduct and complete the investigation within a reasonable amount of time, given obviously the unique facts and circumstances that are presented, and also added what's required by law.
Great. So, after a company learns of a triggering event, as you mentioned, what are the steps that employers need to take in an internal investigation?
So, an effective investigation, follows an established framework. It's fair and impartial, it's timely initiated and completed, it's thorough and accurate, and in line with applicable law and employer policies. Investigations that don't satisfy these requirements won't stand up to administrative, judicial, or even employee scrutiny. Overall, there are 10 key stages of an internal investigation. Let's go through them. Stage one is to determine the triggering event, like Mike was talking about, and have that complaint put in writing. As Mike previously mentioned, the nature of the triggering event will have various ramifications on the subsequent investigation that you will need to consider at the outset. You should also have the complainant employee or employees put their complaint in writing and provide as many details as possible so to avoid later accusations that the employer failed to investigate the employee's complaint fully. The next step is to determine the scope of the complaint. Once you talk to the complainant or complainants and to identify the universe of their allegations, you have to decide exactly what you're investigating, which is called the scope. You put the scope of the investigation in writing so you can review it later. Determining the scope of the investigation as soon as possible is of vital importance since this scope affects every other component of the investigation and will impact your ability to recommend an appropriate and effective resolution. You want to keep in mind that the triggering event is sometimes just the tip of a much larger issue, so be prepared to expand the investigation scope as the facts are determined. Step three, or stage three, is to take interim steps and identify and contain interim risks. So while you're evaluating the triggering event and scope, it's important here at this point to determine whether any interim steps must be taken. For example, if the triggering event involves any type of criminal activity, such as the finding of illegal substances or learning of on a person or destruction of property, it might be necessary to immediately alert the police to alleviate company liability. The company may also want to involve the employer's insurance carrier if the employer has an insurance policy that covers the complaint. Another example would be the receipt of an attorney's demand letter, which would normally require a prompt litigation hold. Imposing a litigation hold, when appropriate, helps contain the risk of spoliation of evidence, which would result in the court, if it goes as far as litigation, assuming the destroyed evidence was favorable for the opposing party, so the party that didn't destroy the evidence. And don't forget to stay attentive throughout the investigation for risks that develop or otherwise become apparent at a later time. Be alert to individuals and or circumstances that might interfere with your ability to conduct an effective investigation or harm the employer, customers, clients, employees, or others. Anonymous threats, for example, also may require administrative leave to protect employees while the investigation is pending in an attempt to prevent interference with the investigation or other harm that the employer cannot otherwise effectively manage. Your next stage is to identify and analyze applicable law, employer policies, and contracts. A lot of the time, this can be helped, the employer can be helped with this by an attorney in-house or outside counsel. The next step is to devise an investigation plan, and Mike will provide more details on how to put an investigation plan together in a few minutes. Stage 6 is to gather and preserve relevant evidence. You want to collect all relevant documentation, safeguard key electronic data, and ensure that the physical evidence is stored to properly avoid deterioration. And you consult with your IT and others to determine whether any potentially relevant data has been destroyed, and if so, whether it can be restored. Stage 7 is to conduct witness interviews, and I will talk about this more in detail later on in the presentation. Stage 8 is to document the investigation. Thoroughly documented investigations help employers justify their decisions and rebut claims, establish credibility, assert defenses, and preserve privileges during government agency investigations and litigation. Consider throughout the investigation whether the documents individually and collectively demonstrate that the investigation was fair and impartial, timely initiated and completed, thorough and accurate, and in line with applicable law and employer policy. Stage 9 is to report the findings, recommend remedial action, and communicate the decision. And we'll talk about this again more in detail later on in the presentation. Finally, stage 10 is your post-decision follow-up. So at the end of the investigation, it's really important to perform an internal audit for those that may have allowed the event to occur, review and revise policies and procedures as appropriate, and evaluate the effectiveness of the investigation that was performed for later investigations.
What are some of the challenges, Mike, that an investigator may face in conducting this kind of investigation?
Sure. Organizational culture and circumstances, workplace tensions, and occasionally interpersonal dynamics and agendas may present significant challenges to conducting an effective investigation. Occasionally, an employer may attempt to rush the investigation because it occurs during busy hours, or if there's a high-ranking or star employee involved, or there even might be situations where the decision about the investigation has already been made. So yielding to these influences will almost always escalate as opposed to de-escalate the situation. It creates a substandard record, and it really undermines the employer's defenses in litigation. So the company should have workarounds in place that will overcome, or at least try to overcome, some of these obstacles.
So let's get to the nuts and bolts here. How does a company go about devising an investigation plan?
Sure, I'll take that one. As Madeline said, the first thing is determine the scope. Once you've determined the scope of the investigation, what the facts are, what the allegations are, then there are several steps that employers should put in place to go about diving into that investigation. First and foremost, is to identify the person who has the overall responsibility for the investigation. Usually, an attorney is best suited for this position, and we'll talk about the reasons for that in a second. You also want to, secondly, you want to select managers or HR professionals who will conduct investigations and interviews, working with that individual who's been charged with the investigation hand in hand. If the employer is relying on a workplace investigation as a defense, the investigator should be an unbiased, neutral, objective third party. An HR person who reports to a C-level executive, for instance, is not the best person to be involved with an investigation or involving the C-suite executive. Similarly, general counsel who report up to the CEO should not be doing investigations involving the CEO. Pretty common sense stuff, but again, just good things to remember at the outset of investigation. In-house counsel should think carefully before engaging a non-attorney to conduct the investigation. And here's why. While non-attorneys may certainly have competence and experience to do an investigation, the employer may not be precluded from asserting attorney-client privilege or work product doctrine to non-employee or non-attorney investigations. So even if that person has a law degree, for example, should in-house counsel nevertheless choose to engage a non-attorney, in-house counsel should always oversee all the non-attorneys' work product and communications to help preserve any applicable privileges or shields that may be in place for any potential disclosure of those communications. So again, generally the best selection for folks to be involved in this investigation are outside counsel. Next, you want to determine which witnesses should be interviewed. Depending on the need for confidentiality, it may be appropriate for the company to limit the witness interviews to current employees. When you interview former employees or third parties, there's a risk that that investigation could become public, and the communications and findings of that investigation become public, and therefore you have issues with, again, confidentiality. Some of the possible witnesses, and the best place to start, obviously, if you have a workplace complaint, is to talk to the complainant, the individual bringing the complaint. You also want to talk to any employee or employees who are accused of wrongdoing. You also want to talk to the supervisors of either the complainant or any of the alleged wrongdoers, and any other witnesses who may have observed or have knowledge of any of the improper conduct. Next, it's necessary to take action and reassess the alleged wrongdoer temporarily, whether or not they're going to continue to work there or not. So again, I'll go back to where I started. I emphasize that it's imperative to take steps to preserve the attorney-client privilege and any work product that's created during this investigation, and confidentiality at the outset and throughout is paramount. So hope that answers it.
Great, thank you. So you mentioned witness interviews. How should those kind of interviews be conducted, Madeline?
Yeah. So witnesses should be interviewed according to the breadth of their knowledge of the subjects or issues being investigated, typically beginning with lesser involved, overview witnesses, then to lower level fact-intensive witnesses, followed by more senior witnesses, and concluding with the individual or individuals suspected of wrongdoing. The company will likely want to have all this information all information as possible, as much information as possible, before interviewing the latter categories of individuals to ensure that the company can dictate the terms of the interview and ask questions that lead to specific information that the company will need to obtain from those individuals to properly conduct the investigation and figure out what remedies are necessary, if any. Each interview should be conducted separately in an office room or room where the discussion will not be overheard. If you're recording the interview, you really need to make sure you comply with all applicable state laws regarding the consent of the interviewee. And employees should be informed that the attorney conducting the investigation, if it's an attorney, is the attorney for the company, so that there's a disclosure there that's required under law. And the employee should also be informed that the company will endeavor to limit disclosure of information related to the allegations and the investigation to only those who really need to know, but they can't guarantee absolute confidentiality. And employees should be informed that they're protected from retaliation for participating in the investigation. That's a pretty important one. And don't forget to consider union representation issues. If the company is determining whether or not something happened, speak to as many people as necessary to make a determination about the allegation. If the investor decides not to interview someone, the investigator should make a note why. And be sure to keep in mind that any notes could be evidence in an administrative charge or a lawsuit while you're writing these notes. The investigator might have to interview witnesses more than once, especially the complainant and subject, if the investigator is receiving conflicting information. And that's pretty much how witness interviews should be conducted.
So, Mike, what should the company do after the investigation is complete?
So many investigations conclude with a written report done by the investigator that often serves to support the employer's legitimate business reason for its employment decisions going forward. After review of the investigator's report, the company must determine and implement disciplinary action against the wrongdoer, if appropriate, and determine the appropriate remedy, if any, for the complainant. Afterwards, the investigation's results should be communicated to the complainant, the employee accused of the misconduct, and the employees affected by the investigation, if that's somebody outside of those folks. It is important to take steps to ensure that communication of the results of the investigation is limited, again, to those who need to know, and those who need to be apprised of the business's reasons for the investigation. And again, don't forget, continue to take steps to ensure supervisors or coworkers do not retaliate against the complainant or other witnesses involved in the investigation. It's really important to remember, even after you've gotten to the end of the investigation, you have to keep those safeguards in place.
And why is it so important to ensure that a proper investigation takes place?
I'll field this one. In the most basic sense, this is to limit the company's exposure to civil and criminal liability, as well as penalties from governmental agencies. To limit this type of exposure, employers should work with their counsel to review and, when necessary, to revise their compliance program to ensure that a proper reporting scheme is in place with all appropriate documentation. It's all about protecting the company's interests and being prepared for potential litigation that may follow. The better and more thorough the investigation is, the better the company will be and the more prepared the company will be in the event that it finds itself in court.
So we talked about the employer. Madeline, what employee rights should the company be concerned about while conducting one of these types of investigations?
Yeah, so the procedures for an internal workplace or HR investigation are often detailed in an employee contract or an employee handbook. These provisions often vary by employer. However, they generally require that all workplace investigations be performed promptly, give you an opportunity to be heard, or the employee an opportunity to be heard, that they forbid decision makers from having a conflict of interest in an outcome, that to give the alleged wrongdoer access to information or subject matter that that's being used against he or she in the investigation, to give the employees access to their personnel records upon request, to give employees access to reasonable accommodations for a disability, though the employer may request medical documentation, and to protect employees from termination or other disciplinary action if no evidence of wrongdoing is found. State and federal employment laws provide numerous legal rights to workers who are the target of a workplace investigation. For example, an employer cannot take negative employment action against an employee through an internal investigation because the employee filed a discrimination claim or harassment complaint, reported a violation of law that's happening in the workplace, like fraud, to law enforcement, requested reasonable accommodations for a disability, or acted as a whistleblower. If an employer violates any of these rights, the employee can often file a lawsuit against them. Employees also have the legal right not to participate in the investigation. However, if the employee's the employment contract requires the employee to cooperate and answer questions honestly, invoking this legal right to not participate in the investigation often leads to termination. While refusing to cooperate can stop the company's investigation into potential criminal activity, for example, the employer may forward its investigation report to law enforcement to continue the investigation process outside of the company. In a whistleblower context, employers will almost always attempt to limit dissemination of information related to an internal investigation on a need-to-know basis. However, sometimes the law protects the anonymity of a covered whistleblower's identity to an even greater extent. Moreover, disclosing or investigating a whistleblower's identity may subject a company to liability just in doing that.
That's great information. Thanks, Madeline.
Mm-hmm.
So what is an employer forbidden from doing during an investigation, Mike?
A lot of things. During an internal investigation, employers, number one, and probably most importantly, cannot violate an employee's privacy rights. If they do commit an invasion of privacy, it can lead to a lawsuit. Some of the most common examples of employers violating employees' privacy rights during an investigation are such things as searching through an employee's personal phone without consent, demanding an employee's personal passwords or login information, demanding an employee's confidential health records, recording phone calls or interviews in violation of state wiretapping laws, or monitoring employees' work activity in ways that aren't contemplated by the employee's contract. However, many employment contracts, the private sector at least, look ahead to these situations and give the employer some latitude to monitor employees and search their belongings in the workplace. For example, employment contracts frequently include provisions to allow employers to monitor employees' computer usage or provide access to employees' work mail. And sometimes contracts will state that the employee's belongings can be searched when brought onto the premises. So it's always a good idea to have the employee sign a confidentiality agreement, preferably at the outset of the employment. And even if the employee does not sign such a document, there are situations where the employee may be able to break confidentiality, such as report workplace harassment or discrimination. So try to get as much protection as you can in the contract as an employer, but there are situations where the employee has some workarounds. So.
All right, great. Madeline, any final thoughts before we get to the Q&A?
Yeah, so, in conclusion, when a company learns of a triggering event, it's really important to act promptly. In doing so, it's best practice for a company to seek immediate advice from counsel so to limit any potential liability due to the triggering event's occurrence, and that the company might incur while conducting the investigation, such as we just talked about, all the laws and all of the rules we have to follow to make sure that there's no liability on the company's part.
All right. So viewers, now that you've gotten a taste of what an internal investigation entails, we can answer some of your questions. Anything we don't get to will be answered via email directly after today's webinar. So we've got a couple of questions coming in. The first one is, what should non-manager and manager employees be told about regarding an investigation? Who would like to
Yeah,
take that one?
I'll take that one. So for non-managers, so just regular non-manager employees or non-C-suite level employees, they should be told not to talk about the investigation while it's ongoing, because doing so might jeopardize the investigation's integrity. On the managerial side, they should be instructed not to talk about the investigation at all because it's confidential. The difference in treatment between managers and non-managers is because talking about workplace investigations after they conclude might be a protected concerted activity among non-managers. It's not the same for managers.
All right. Another question here. How long should an employer keep records of the investigation and evidence collected?
I'll take that one if that's okay.
Mhm.
Like most situations, and then especially in litigation, which is where I focus, it's important to preserve evidence. Employers in situations like this need to preserve relevant documents when they perceive a reasonable risk of litigation. Besides this obligation, employers may have an additional obligation to preserve evidence when a whistleblower comes forward, for example. In certain circumstances, the employer may also have an affirmative obligation to thoroughly investigate. To satisfy this obligation, the employer must preserve documents and records that relate to the allegations raised in the whistleblower's complaint so that they can be reviewed as part of the investigation. So pretty much whenever an employer confronts a whistleblower complaint, the employer's obligation is heightened and the duty to investigate exists. In addition to determining whether the employer's obligation to preserve evidence has been triggered even more broadly than that. So the bottom line is the employer needs to take special care to identify and preserve documents that have any bearing or relationship to the investigation. Again, it's all about preserving the company's interest and being fully armed in the event of litigation. So hopefully that answers it. Good question.
Great. For more information on our employment law services or any of our other practice areas, visit kelleherholland.com or send us an email to attorneys@kelleherholland.com. Kelleher & Holland's Employment Law Lunch and Learns are prepared for the general information of clients and friends of the firm. It is not intended to provide legal advice with respect to any specific matter, nor is it intended to create an attorney-client relationship. Under rules applicable to the professional conduct of attorneys in various jurisdictions, this may be considered attorney advertising material.